Hello everyone, welcome to Linda Liu IP course. I'm patent attorney Baoyu Zhang. Today I'm going to discuss the key amendments to the guidelines for patent examination with my colleague Tao Chen. Effective January 1st, 2026, the newly revised guidelines for patent examination officially take effect. From closing the dual application loophole to establishing compliance rules for AI algorithms, from aligning the definition of plant variety with the Chinese seed law, to providing the first clear criterion for bitstream subject matter. This single amendment simultaneously covers three major dimensions: examination procedure, substantive requirements, and industrial-related field. We will highlight the most noteworthy changes in the revised guidelines for patent examination and present them in two parts. 1. Blocking dual application arbitrage. The dual application mechanism returns to a strict either-or choice. Under the original dual application system, the same applicant could, on the same day, file both a utility model application and an invention patent application for the identical invention creations. This allows the applicant to first obtain protection through the quickly granted utility model, 10-year term, and then, after the invention patent passed the substantive examination, voluntarily renounce the utility model and retain only the long-term lasting invention patent, 20-year term. In practice, however, some applicants would amend the claims in the later examined invention application to differ in scope from the already granted utility model, thereby enabling them to retain both the utility model and the invention patent simultaneously and achieve double protection for essentially the same technical solution. The new guidelines tighten the valves completely. 1. Applicants must explicitly select the dual application option and make the corresponding declaration on the filing date itself. 2. Before the invention patent is granted, the applicant must proactively submit a written statement voluntarily renouncing the utility model. Otherwise, the invention application will be directly rejected. 3. Renunciation statement will be published together with the grant announcement of the invention patent, and the utility model right will terminate as of the grant date of the invention patent. In short, any attempt to retain due protection by creating differences in claim scope is completely blocked. Consequently, it will no longer be possible to obtain an invention patent for the technical solution already defined and protected by the utility model patent. If applicants truly need both types of patents, they can consider trying the ordinary same-day filing route and, from the drafting stage, divide the claims into non-overlapping technical solutions. 2. Introduction of the technical contribution principle in inventive step assessment. Irrelevant features no longer count. The new guidelines expressly state a feature that does not make substantive contribution to technical problem to be solved shall not support inventive step, even if it is recited in the claims. Examination will return to the strict technical problem solution effect chain. The description must first clearly identify the technical problem to be solved, and then demonstrate the causal relationship between the features as means for solving that problem. The key focus will be on whether the features recited in the claims made a substantive contribution to the technical problem actually solved by the invention. Failing to clearly state the technical problem and technical effect will place the application in serious jeopardy during inventive step examination in China. It's therefore recommended that where a PCT application is intended to cover multiple jurisdictions, the national phase test entering China will adaptively supplement it to explicitly highlight the corresponding technical logic between the technical problem and the key features, and that The description be further amended to add technical effects with respect to important technical aspects. 3. Invalidation requests now require to wear a real identity bracelet. Using strawman entities to file invalidation requests has long been a gray area tactic in patent wars. To conceal the true commercial conflict, competitors often hide behind affiliated companies, employees, relatives, or other nominees to launch waves of invalidation proceedings. The new guidelines explicitly classify non-genuine expression of intent as grounds for non-acceptance. When the patentee receives a suspected strawman invalidation request, they may file an objection with the CNIPA, demanding verification of the requester's true identity as well as the authenticity of the signature and the power of attorney. The patentee may also request the CNIPA to retrieve notarized records or conduct an on-site verification. For the genuine party who chooses to file an invalidation through a third-party nominee, they should prepare in advance sufficient evidence proving both genuine intent and valid authorization. For example, notarized declaration, video recorded witnessing, statements of motive, etc., so as to avoid having the invalidation request rejected on formal grounds. 4. Definition of plant variety, aligned with the seed law. Intermediate breeding material become patentable. 1. Introduction of the new concept of plant variety. The term plant variety, as used in the patent law, refers to a plant population that has been artificially bred or discovered and improved with consistent morphological and biological characteristics and relatively stable genetic traits. By aligning this definition with the Chinese seed law, breeding materials that previously could not obtain patent variety rights now have the opportunity to be protected through invention patent. 2. Wild plants found in nature without technical treatment and their naturally occurring stage remain scientific discoveries and are not patentable. However, if they have undergone human intervention and possess industrial applicability value, they will no longer be excluded from patentability. 3. If the population traits are not yet stable, the subject matter will not be regarded as a plant variety. This allows it to bypass the prohibition under Article 25 of the patent law that patent variety are not granted patent, thereby opening the door for intermediate breeding material to be protected via patents and significantly expanding the scope of patentable subject matter. 5. Practical recommendations. 1. On filing stage, if a product needs to be launched quickly and requires patent protection as soon as possible, the dual application system may continue to be used. However, if the applicant subsequently wishes to obtain an invention patent right directed to the technical solution already defined in the utility model, the claims of the invention application and the utility model application shall be drafted identically, and the dual application declaration must be selected on the filing date. If the applicant can accept that the scope of protection of the invention patent right will be different from that of the utility model, the declaration need not be selected, but it must be ensured that at the time of filing, there is no identical scope of protection between the utility model and the invention application. For the Chinese patent application, adopt the state the technical problem first, then the solution approach. Clearly establish a one-to-one correspondence between the technical features and their technical effects to minimize the inventive step disputes. 2. On post-grant stage, upon encountering a suspected strawman invalidation request, within 15 days, submit a written request to the CNIPA demanding verification of the requester's true identity and simultaneously collect the evidence of the opponent's commercial connections. In cases of multiple strawman attacks in batches, invoke the grant of a non-linear expression of intent to try to have the request dismissed outright on formalities, thereby saving defense costs. 3. On portfolio planning stage, chemical and pharmaceutical companies may draft claims for intermediate breeding materials whose traits are not yet stable in the form of a product plus preparation method plus use combination to see the patent protection gap. Adopt a dual-track protection strategy combining plant variety rights and invention patent. The former grants the breeding entity or individual an exclusive right over the authorized variety, while the latter protects the intermediate breeding materials. That is the part 1 we would like to share. My colleague Tao Chen will continue with the next part.